Well, welcome everyone to our afternoon session, or first afternoon session. I am Pierre Verdier from UVA Law School, for those of you who don't know me. And we have a group of, really a scintillating group this afternoon to tell us about the role of international law and the making of the Fourth Restatement. First, Ed Swaine, Bill Dodge, and Bakhtiyar Tuzmukhamedov. I am told that some introductions have already been made this morning, so no further introductions are needed, and we're ready to go ahead. So we'll start with Ed.
Thank you very much, Pierre. And thank you, obviously, to the University of Virginia for hosting this, and also to Paul for providing leadership in this and in our Restatement project in general. So I want to try to, I guess, rehash the discussion paper to a certain extent, but also expand it in light of the panel and its project. The paper is, let's be frank, kind of a boring little methodological piece more than it is anything that provides much substantive insight. But the question is ultimately about the kinds of materials with which the Restatement Fourth has and should be wrestling, and a comparison between it and the approach to international law, which is obviously something of keen attention to the Restatement Fourth as it was to the Restatement Third. So the Restatement Third, as some of the other papers, both in this panel and other papers discuss, was notable for its enthusiastic embrace relative to the prior restatement of international law. And its approach to that was perhaps something like the enthusiasm, say, of a convert. It found it quite enthusiastically and happily most of the places it chose to look. And it, as the discussion draft noted, in principle, it embraced a traditional view of international law in terms of sources and evidence. It considered the typical things one would look at in those regards, and focused mainly on international agreements and customary international law. And conventionally, at least, it said the right things about how that was to be found and articulated in turn by the restatement itself. It was not completely successful, despite its attempts to eschew a U.S.-focused view. It ended up with some distinctive views that were based in part upon its approach to state practice, which ended up being a very U.S.-focused kind of state practice. And in a few areas where it wasn't so inclined, it ran into some difficulties in dealing with one of the parties with which restatements in this field tend to deal with, which is the U.S. government, and in particular the State Department. And so there were interesting exchanges on topics such as expropriation, for example, as well as the reasonableness topic, the reasonableness in prescriptive jurisdiction. And so this suggested that there was, in fact, sort of a U.S. focused view or a different approach in practice that one might have to international law. And there's nothing quite like that in the Restatement Fourth to this point. There is use of international law quite heavily in some areas, but there wasn't an attempt yet to define what international law is, or the kind of international law with which the Restatement Fourth should really be grappling. It more or less took the field as a given and embarked on it. And in the discussion paper, I explained that I think, and I would say this, I suppose, that this was a considered view, and that trying to define the parameters of international law and the kind of proof that one might want of international law more generally would have been kind of a hazardous thing to do, given that only parts of the Restatement Fourth have been authorized, and you don't want to bite off more than you can chew, or hem in future discussions with a full considered view of all the topics that you're going to be considering. So something similar might be going on in an area that's of keener interest still to the reporters and to the Restatement Fourth, and that is to do with the understanding of foreign relations law, which is partly international law and partly not. The Restatement Third defined this field as, at least for purposes of that restatement, as being international law as it applies to the United States, and domestic law that has substantial significance for the foreign relations of the United States or has other substantial international consequences. There's nothing exactly similar to that in the Restatement Fourth to this point. There is a discussion of a brief narrative depiction of what foreign relations law is drawn from in a non-exclusive kind of way in the introduction. We did discuss a section that would be set out a different definition that was discussed among the reporters. It was finalized to some degree or another, but it's not been published and it hasn't been subject to the full process. And so the paper is trying to decide, well, what kind of indications do we have about how this is going to be understood or detected by the restatement? And more importantly, what do I think, just my personal views, of course, what do I think this maybe suggests about some potential things we want to be careful about? Or in taking on new sections, what do we want to be wary of either not doing again, or more importantly, where do we think potential problems might lie? So, putting aside the question of the substantive scope of what foreign relations law is, the issue is more given some type of scope of what it covers, what kind of thing, what kind of evidence, what kind of fact falls within that, and what should we be paying attention to, really, in trying to decide? It's like you're engaged in something like this. Actually, this is a very unattractive metaphor, but it's like you're engaged in something like redistricting, and the question is not so much where you choose to draw the lines in defining the district, but it's more sort of like who counts as a voter? What constitutes proof of life within that district? And so this naturally is the kind of question that international law has long wrestled with in terms of the distinction between sources and evidence. And looking at the Restatement Fourth, we have some really easy pickings in terms of what our sources ought to be. In other words, it seems very clear that reporters in dealing with future sections of the Restatement Fourth, as is the true of the ones that we've talked about so far, want to be dealing with the U.S. Constitution, they want to be dealing with federal statutes, they want to be dealing with not just treaties, but presumably other international agreements as well. They want to be dealing with state law, including on a lot of important questions covered in the jurisdiction section. They want to be dealing with case law because of the U.S. System of articulating the common law method and also Supreme Court interpretation of the Constitution. Want to deal with executive branch rules and regulations. But we do talk about other things without really having a clear understanding of what counts as evidence of those things, or what counts beyond the law that any lawyer would mention when it's not necessarily authoritative of the as to the particular issue being considered. And so if we were to talk about, executive branch, say, omissions of some kind in connection with a problem of international law, an international lawyer would look at them and say, well, does this comment, does this practice, does this thing that is being reported to me, does it relate to an agreement or customary international law, or are we forced to relegate it to the bleachers with soft law and the like? They'd know they want to first do this kind of sorting function to with what do we associate this statement, and then they would think about whether it's the kind of evidence that counts, and they would have readily available a set of tools that they apply erratically, of course, but for figuring out, well, is this part of a consistent treatment of this issue by this particular actor? Is that treatment by that actor consistent within that relevant state? Is it consistent, is this state's behavior, if it's consistent internally, is it consistent with the behavior of yet other states? And they'd go forward and build this question. This is, I think, to this point, less clear in the field of foreign relations how exactly we should do that. We know that we say, as a matter of restatement law concerning foreign relations, that whether international law is established in the fashion I just described doesn't exhaust what we talk about as relevant for foreign relations law. We are interested in things that are unique to the United States and idiosyncratic for the United States. But how we make the decisions as to what counts exactly remains a little unclear. So some of the things clearly matter. Other stuff, such as what the executive branch does, is less clear. It will matter, for example, whether it purports to be interpretive of the Constitution, whether it purports to be interpretive of a statute or of a treaty. But there are other instances in which what the executive branch or what some other actor within the U.S. system is doing simply exemplifies a tendency or establishes a position with respect to other law or other state practices that might be relevant. And as the discussion paper indicates, I think we find this to be true, and my examples to this point, which have been a little opaque, I admit, mainly relate to the executive branch. I think we may find as we go forward, we want to be careful about some of the tendencies that I think people within foreign relations generally and within the restatement process might have. One question I mentioned in the paper is we should be interested in what happens when we don't have evidence establishing a position or a commitment to, say, a proposition of customary international law, or say with respect to a particular kind of treaty practice that we see exhibited elsewhere. What does it matter if, for example, we don't find examples where the United States has done things in that fashion, has exercised jurisdiction in a way that other states have exercised? What significance do we attribute to the omission or the lack of evidence in that regard? And I think I think it matters, but how exactly it matters is a little bit difficult. It was a little bit difficult for me to say, and I'm interested in input on that question. I'm also interested in the question about what it matters, to what extent it matters that the United States, say, on a given issue, has not manifested a final or most conclusive position that it might have. So what does it matter if the United States government has indicated support for the Vienna Convention on the Law of Treaties, for example? To what extent does it matter, and attested that large parts of it at least are customary international law, to what extent does it matter that it hasn't committed to that and ratified that treaty? To what extent does it matter if there is a practice common within the State Department that has not made its way into Circular 175? To what extent does it matter if, to turn the tables a little bit, there is a consistent position that members of the legislative branch have exhibited that has not made its way into a binding statute? To what extent should we pay attention to that? That seems to be practice of the kind that would be reported maybe in the practice digest. But what extent should we try to take this into account within the restatement process? And I think we have to be sensitive to this, in part because one of the things I think many of us saw in the restatement process is it's much easier to get information and input from actors within the executive branch within the Justice Department and within the State Department than it is to extract the considered view of participants within the legislative branch. And there's a lot of reasons why that might be so. That might be simply a reflection of how foreign relations law is generally generated within the world. And we might simply view the restatement process as simply a microcosm of how foreign relations law really works. But I think we have to be wary of accepting that easy answer. And we have to see whether there's ways in which the restatement should form its view within itself. Courts always remain free to reject this. But I think we have to be careful about how we cast our net and how we decide what significance we attribute to other materials like this. That's why I stop there.
Thank you. Bill?
Great. Well, Ed began his paper by noting the description of sources of foreign relations law in the introduction to the restatement, and maybe I'll just read that. The foreign relations law of the United States is drawn from different sources, including the Constitution, congressional legislation, judicial decision, actions of the executive, customary international law, international agreements, and state law. This restatement attempts to distinguish clearly among these different sources and to explain their interrelationships with respect to the particular topics covered here. It's really that last part that I focus on in my paper, and my contribution tries to distinguish between international law and international comity. And I also try in the paper to defend the Restatement Fourth's reliance on international comity. Now, because I have written an article on international comity, I fear that people will attribute this reliance to me. I will state for the record that I do not deserve all of the credit or all of the blame for the mentions of international comity in the document. As I recall, it was frequently Paul or Anthea who would send a draft that described something as international comity. I did not object to the inclusion, but I did not always initiate the inclusion. So the Restatement Third actively avoided using the word comity, and I think there are two reasons for this. First, the Restatement Third wanted to restate international law, and doctrines based on international comity are not doctrines of international law. Second, the reporters of the Third Restatement thought that comity was the antithesis of legal obligation. I think the most famous example of emphasizing international law over international comity is Section 403 of the Third Restatement, which was built on top of cases like Timberlane and Mannington Mills that viewed their limitations of extraterritoriality as examples of comity. Section 403 took these cases and it fashioned a rule of customary international law. But in doing so, the Restatement Third ignored its own tests of state practice and opinio juris. Almost the only state practice cited in support was that of the United States, and the U.S. cases had not acted out of a sense of legal obligation. I think another example of the same dynamic is jurisdiction to adjudicate, where the reporters essentially took the Supreme Court's due process jurisprudence circa 1986 and wrote it into Section 421 and called it customary international law. Again, almost all the practice cited was U.S. practice, and again, there was no discussion of opinio juris. I'm sure we'll talk about this tomorrow morning in connection with Austin's paper some more. I have enormous respect for each of the reporters of the Third Restatement, but I do think they erred in two respects. First, I really firmly believe that they should have followed the Restatement Third's own test for customary international law, requiring a general and consistent practice of states followed out of a sense of legal obligation when they were trying to restate rules of customary international law of jurisdiction. Second, I don't think that they were right that comity is the antithesis of legal obligation. It is absolutely correct that rules of international comity do not reflect international legal obligation, but they certainly can reflect domestic legal obligation, and they can take the form of rules, not just the form of standards. The Restatement Fourth took a more cautious approach to restating customary international law, and that correspondingly meant that it was more open to restating domestic law. The Restatement Fourth's reporters also did not shy away from international comedy. To the contrary, we found it a useful tool for distinguishing rules that are part of domestic law and required by domestic law, but not required by international law. With respect to the extraterritorial application of U.S. law, the Restatement Fourth significantly rejects Section 403 as a rule of customary international law because it is not supported by state practice and opinio juris. To Ralph and Hannah's chagrin, it also rejects Section 403 as a rule of U.S. domestic law based on comity. And that's because it also doesn't reflect the practice of the U.S. Supreme Court, even though some lower courts continue to follow something that looks like 403 in certain contexts. Instead, what the Restatement Fourth does in Section 404 is restate the presumption against extraterritoriality, which is the principal tool the Supreme Court has used to answer questions of geographic scope for the last 3 decades. Section 405 then goes on to supplement the presumption with a principle of reasonableness in interpretation based on the Empegran case. This carves out a space for some of the lower court cases that have applied case-by-case balancing in certain contexts. And I think properly read and read together, 404 and 405 allow courts a good deal of flexibility to tailor the geographic scope of U.S. law provision by provision. Indeed, Section 404 tries to restate the presumption against extraterritoriality in the most flexible terms possible. But unlike Section 403, old Section 403, it generally does not allow U.S. courts to make case-by-case determinations not to apply U.S. law based on conflicts with foreign law. So if I had to characterize the basic difference on this point between the two restatements, the Restatement Fourth allows for provision-by-provision determinations of geographic scope. The Restatement Third called for case-by-case determinations of whether U.S. law should apply, and I see those as fundamentally different. I think the rejection of case-by-case discretion is in fact most consistent with what the U.S. Supreme Court has said and done over the last 3 decades. I also think that this case-by-case discretion is a discretion that is in some ways too easy to abuse. And I think this is a point that Tom Lee makes in his paper about the Restatement Fourth, and I think accurately that to some extent, at least on some issues, the reporters were being a little defensive, not wanting to give too much discretion or authority to judges. And I would add that this case-by-case discretion is a discretion that many federal judges don't seem to want. At least those who served as advisors on this project and spoke to the question seem to be unanimous in not wanting to have to weigh all of these factors to figure out whether U.S. law should apply. I won't go into the same level of detail about other comity doctrines. Suffice it to say that the Restatement Fourth also tends to view limits on jurisdiction to adjudicate, the active state doctrine, foreign state compulsion, and the recognition of foreign judgments as doctrines of international comity. Now, I also view much of foreign sovereign immunity as international comity. Cue Dave Stewart to interject and correct me. I certainly recognize that there's a core of international law here that is supported by state practice and opinio juris, and therefore required by customary international law. But I think much of what states do in this area goes beyond rules that we can find that kind of support for. In the time remaining, I want to offer some thoughts about what this shift from international law to international comity portends for U.S. foreign relations law. First, it does not mean unbridled judicial discretion. There are certainly some doctrines of international comity, like forum nonconveniens, that give great discretion to U.S. courts, but most of them do not. Think of the active state doctrine, for example, or the rules about enforcing foreign judgments. And ironically, the comedy-based rules on extraterritoriality in the Restatement Fourth actually give U.S. courts less discretion than the supposedly customary international law-based rules that you found in the Restatement Third. The second implication is that I think thinking about something as international comedy does mean that nations have discretion about how to shape those doctrines. I give examples in the paper where the U.S. presumption against extraterritoriality, rules on forum nonconveniens, the enforcement of judgments, the active state doctrine differ from some of their foreign counterparts. If we understand these rules to be based on international comedy, it allows for divergence in these rules in ways that basing them on international law would not. Third, I think tying these doctrines of domestic law to international comedy identifies a fundamental underlying connection. Most fundamentally, these doctrines all serve to mediate the relationship between the U.S. legal system and the legal systems of other states. International comedy provides a range of tools for doing this, from the doctrine of forum nonconveniens, which focuses on whether the case is in the right forum, to the presumption against extraterritoriality, which focuses on applicable law, to the doctrine of foreign state compulsion, which creates an escape hatch in some situations where a person really is stuck between a rock and a hard place. So we have different problems that arise, and we have different tools based on international comedy to solve those problems. And fourth and finally, I think the toolkit is not closed. Courts can develop new tools, and they can modify existing tools. The Supreme Court could adopt the case-by-case approach that Ralph and Hannah advocate if it wants to. That is a path that is open to them. Congress can intervene if it wants to. So can state legislatures on at least some questions. To anticipate G-Day a little bit, the Restatement Fourth, I think, can bring a certain stability to foreign relations law, but this is a law that can change and will continue to change. And so after some period of years, we will need a Restatement Fifth of foreign relations law. And I hope that I will be invited to the Sokol Colloquium that discusses it. Thank you.
Comments or questions lined up? If you have one, please put up your placard and I will go around the table. So we'll start with Paul, who will tell us about the Arabic and Chinese text of the charter.
I defer to Bill completely on the Chinese, and I defer to anyone else on the Arabic. First a comment about Ed's presentation and then a question for Bakhtiyar. I mean, one of the things I think is interesting about the reporter's notes in the Fourth Restatement is how extensively we quoted foreign legislation, to a lesser extent judicial practice. And we did get some pushback from our advisors on that, because they said, how are you qualified? Maybe the Russian and the Chinese we knew, but when it came to Albanian and Slovenian and Romanian law, I mean, did we really know what we were talking about? And it was a fair criticism. The effort was to at least signal to others what we thought were the indications of practice. And we looked to this extensive state legislation as evidence of practice, which we thought were helpful as to the issues. To Bakhtiyar, a very, I think, narrow, but maybe broad question, which is really about the relationship between the Charter and domestic law. I mean, you say in your paper that the Security Council has exclusive jurisdiction over the determining of aggression. And is exclusive the right word as opposed to definitive or authoritative? Because I can easily imagine that states, including Russia, can make their own bid on what they think are the contours of a state of aggression and apply that concept to particular facts, with the understanding that it is simply a bid subject to the ultimate authority of the Security Council. which is different from exclusive, as I understand it, which means that you can't deal with it at all. You have to kick it up to the Security Council.
So I wanted to offer at least a partial defense for the exuberance of the third restatement when it comes to articulating rules of customary international law. And I say partial because I'm 100% on board. Okay. I say a partial defense of the exuberance of the third restatement for articulating rules of customary international law, because I'm entirely on board, Bill, with the criticism that you made, which is there's a very big gap between what the third restatement says customary international law is and the actual methodology of the third restatement when it comes to articulating rules. But I think that there's something useful even in being wrong, right? I think that the third restatement, by articulating rules that didn't prove to align with practice and opinio juris, still provided a useful service by providing, if nothing else, a focal point to which other actors, right, judges, political actors, could respond. So I think you might say the third restatement was wrong, but it was wrong in a way that was ultimately constructive. I think the second reason why perhaps the fourth restatement is a little bit too gun-shy when it comes to articulating rules of customary international law is that the restatement has an important pedagogical role to play to practitioners, to judges. It's a resource of first resort to many lawyers and judges who have little exposure to and familiarity with international law. I think by articulating a rule and showing how the methodology ought to work in practice, I think that there's an opportunity for the restatement to play a valuable pedagogical role. And then the third reason, and this one is maybe one to be a little bit more cautious about, but in a situation where a rule has not entirely clearly coalesced, where the proof is maybe there but not quite 100%, there is a capacity for the restatement to play a useful role in facilitating the ripening of a rule. And even looking at the third restatement rules that ultimately didn't align with practice and opinio juris, the world in which they would have aligned isn't one that looks so different necessarily from the one that we live in, and had a couple of Supreme Court justices sided with Justice Scalia in Hartford Fire Insurance, right? Like the rule could have gone, or the real world could have perhaps reflected the articulated rule far more closely, making it a decent bet looking at it from an ex ante perspective. So keeping in mind those ways in which it's possible for the restatement to be both wrong and constructive, I'd be curious about your views and the views of other reporters about whether you think maybe there's a possibility that you were a little bit too gun-shy.
Bill, did you want a chance to respond?
Well, how many of them are we going to, I mean, I think, do you want to, I'm happy to respond, but maybe people should respond to Paul as well at that point.
Maybe, why don't we take one more and then go
Okay,
around the table to
however
respond?
you want to do it is
How
fine.
about that?
Just one quick observation and then a question. So I sort of tend to agree. I think it's important to distinguish between the operationalizing of rules in the third restatement that were controversial and the underlying principles, which were not. And so to me, it may have been controversial that a reasonableness rule was interpreted as how you operationalize customary international law. I don't think it was controversial in a number of areas that customary international law applied and that those were principles of law, not comedy. And so so the bigger question I have, and I can save some of those for tomorrow, but I'm interested, it makes a big point that comedy doctrines, international comedy doctrines, are not required by international law. Why not? So although they don't specify the specific content of those comedy doctrines, why don't you take the duty to cooperate, the duty to negotiate, a good neighbor list, those principles from international law, and say, although they don't create a particular form in which comity requires, that all those cases under the ICJ's sort of decisions require cooperation and taking into account foreign interests. And therefore, at some level, although it doesn't specify the content of the comity doctrines as they play out domestically, it's required for states to have some form of comity, if not some legal principles that take into account foreign nation interests as part of those general principles of international law. And so you may not agree with those general principles, but why isn't it that that's emanating from international law as a requirement for why some form of comity is not required by domestic law, but required by international law writ large?
So I think that, first of all, it's important to distinguish, to define comity. If comity means getting along with other people in the world, then yes, international law certainly plays a role in facilitating comity. I'm using it in a more technical term, in a more technical way, to include just rules of domestic law that are not required by international law that help us get along in the world. So on the general principles point, it's an area of international law that I think is not entirely clear what purpose general principles serve. They're already referred to under the ICJ statute. They certainly form a gap-filling function in some instances. Whether there are general principles that go beyond that, like a duty to cooperate or a duty of good faith, which are international obligations on states, I think is much more contested. I certainly would not have felt comfortable relying on them in the Restatement Fourth to the, on those as opposed to the rules of customary international law, which are generally recognized based on state practice and opinio juris. As to Christina's point, maybe I absolutely agree that it would be extremely useful for people in the United States, including judges, to have good illustrations of how you do customary international law. And I hope that there will be more work on the Restatement Fourth, and I hope that part of that work will be what Ed is suggesting on sources of customary international law, at least. I think the question of sources of foreign relations law is much more difficult because it's much more contextual. But we have rules for how customary international law should be determined. The ILC has done important work recently, completed important work on this as well. And a lot of that could be explained very usefully. I don't think you do any service, though, if you say we have these rules and then you push them or don't apply them faithfully. And I think that includes, I hear what you're saying about when something gets up close to the line. I don't think 403 of the Third Restatement came anywhere close to the line. And so I think that it, in fact, did a disservice. And I think one reason one may, well, I'm not going to blame the Third Restatement for this. There are lots of reasons for the backlash against international law in the United States. But saying that international law contains everything that everyone might want it to, and solves every possible problem, is not a recipe to get people to take international law seriously, in my view.
Well, if I may jump in here, with respect to this to some extent, but also with respect to your answer to Austin, I completely subscribe to your praise for the Fourth Restatement's effort to keep a fairly clear distinction between doctrines or rules that come and do not come from international law. But I do have a question about the use of the term comity to describe or establish that distinction. And the example that comes to mind, and you cite it in your paper, are various cases in which the Supreme Court has kind of casually said things about foreign state immunity to the effect that that is a rule of comity, or a rule that, or they've described it as involving comity. And in my mind, it can't be that they mean comedy in the sense that you're describing it, that it is not a rule of international law. Or at least if they mean that, then it's clearly wrong. As far as I'm concerned, if there is anything that qualifies as a rule of customary international law that is clearly established as such, it is the rule of foreign state immunity. So then the question is, what do they mean? Either they actually do mean comedy in your sense and they're wrong, or they mean something slightly different, which is that it is a rule that exists out there that is comedy, not in the sense that it is or is not international law, but that describes what it's motivated by, which is some deference to the sovereign interests of other states and some need to restrict oneself from fully applying one's jurisdiction in certain circumstances. And so that makes me wonder whether there is some ambiguity built into the term comedy that makes it a sort of problematic label for what you're trying to use it as.
Well, there certainly are different definitions of international comedy, and the restatement does try to adopt a definition that comports with what I've said. And I agree that many rules of foreign sovereign immunity are rules that are required by customary international law. I take a relatively narrow view of what those rules required by customary international law would require. We can talk about this more tomorrow, potentially. So I guess I see in the area of foreign sovereign immunity, as in the area of prescriptive jurisdiction, I see sort of a core of customary international law rules, and then I see a surrounding set of doctrines that are based on comedy, in which nations extend foreign sovereign immunity beyond what is required. The clearest example from U.S. law is the extension of foreign sovereign immunity to agencies and instrumentalities of foreign states. Not required by customary international law, nobody else does it, to state-owned enterprises, for example. So the United States has chosen to do it, that's comedy.
Were there some more answers to?
Yeah, if you don't mind, I will not weigh in on the comedy issue. I do think that it is a concept that's used diversely and has to be examined in each particular context as to whether it's referring to an internationally binding obligation or even a domestically binding obligation. And I think that's the approach generally the restatement takes, is not some kind of trans-substantive sense of what comedy necessarily is. To Christina's point, I mean, I think that's entirely true as an observation, that there's value in being wrong, or there's value in demonstrating method in pursuit of establishing a principle of customary international law, even if one isn't fully fledged. But I try to think of that more as a byproduct or as waste of the process, not as part of the production function. I think there's serious dangers for the reporters where we looked at one another and said, well, it's wrong, but, it's interesting, or at least it will generate an interesting response. I don't think the Institute would have let us get away with that. And I think there's a huge downside in that. One of the things that I've seen in the 30 years of reaction to the Restatement Third is tarring the restatement as a whole and the method and the reporters by virtue of perceived errors in one section, say, that is thought to represent a methodological problem that contaminates the entire project. And I think that's something one has to be very careful about. Paul, I agree with you entirely, and I don't mean to be suggesting that the Restatement Fourth didn't do a wise job of husbanding evidence concerning state practice in the reporter's notes. We got pushback on that, as you say. We got pushback also when in the early drafts there was more such material simply cited for more comparative purposes. And it's that latter part that I think is what troubles me more, not comparative purposes so much as where we're not sure really, or we haven't stated clearly what the evidence is supposed to establish in the end. And I think we know in the restatement, reporter's notes, you mentioned what the end product is supposed to be. It's supposed to be an establishing what is customary international law, or in U.S. judicial practice, what is comedy, that is a rule that has to be applied as a legal obligation, if not an international one. But where we're dealing with something that is as Bill said, necessarily contextual, but also where we're not really sure ultimately what the payoff is in formal legal terms. I think it requires some greater self-scrutiny. We can speculate about what the payoff is in non-formal legal terms. One of the benefits of citing, for example, U.S. executive practice on an area is reducing the possibility of criticism of the efforts as being out of step with some concept of foreign relations law. So there's a lot of potential payoffs. It's just I think we have to have our own internal standard that we're aspiring to.
Paul, I think that the prerogative to determine the act of aggression should stay with the Security Council as its exclusive prerogative. That's my reading of the Charter. If there is a massive armed attack, then it triggers off self-defense, whether individual or collective. That's the textbook. I think that the term aggression has been used both internationally and nationally rather indiscriminately, and it became very, very commonplace. It should be used more sparingly. I'm reminded of a diplomatic anecdote which was told to me by one of the participants when two ambassadors, then Soviet and U.S., were standing in front of the door of the Security Council, which was about to vote on what eventually became Resolution 678, authorizing the use of all necessary means against Iraq. And the two ambassadors were discussing whether the term aggression should be used by the Security Council. One said, let's do it. Both were burdened by a degree of legal knowledge. And the other say no. The other said no. It's all clear. Let's go and vote. They voted, and there was no term aggression in 1991 in 678. How history would have changed had the Security Council identified the aggression at that moment and said that Iraq is responsible for that aggression, because the determination of the act of aggression entails not only general measures against an aggressive state, but also personal measures.
John Harrison?
Yes, okay, yes. I want to ask a question specifically of Ed Swaine and whether the restaters grappled at all with a problem about the interaction between U.S. domestic law and international law with respect to actions of the executive, insofar as they contribute to state practice, because state practice is the conduct of states. Routinely, the U.S. executive acts on behalf of the United States. Congress also legislates. The courts do make decisions. And there are a lot of debates about the extent of executive authority, the extent of executive discretion with respect to foreign relations, and whether you saw it as a problem that there may be actions by the United States that, for international law purposes, would constitute state practice that were taken by the executive and are of doubtful legality as a matter of U.S. domestic law. I'll give one example. I think for international law purposes, the way the international action in Korea was organized, without the actual creation, without the use of UN forces pursuant to an Article 43 agreement, but in a somewhat novel mechanism, that's an important piece of state practice, I think, in glossing the Charter. But for U.S. domestic law purposes, there's a long-standing debate going all the way back to Korea whether it was in fact lawful under U.S. law for the president to participate in that kind of action. I'm sure there are other examples. That one just came to mind. So my question is whether the restaters thought they had to think something about that, given the way that the two bodies of law interact with one another.
Mila proceed.
Okay, great. I don't think I'm pretty loud, right? I don't think do I need this?
Yes.
Okay, sorry. Okay, so I had a question for Bakhtiyar. So I wondered, so some have speculated that the parliaments that are more involved in declaring war or going to war, that actually leads to less war, right? And these countries less likely to fight each other. So there's a paper by Tom Ginsburg where he tries to show this empirically, but this is an older idea in international relations. It's sort of a version of Kant's perpetual peace thesis, if you want. So I was curious, does Russia fit this hypothesis, right? So if there were actually more powers for the legislature and the balance wasn't as much tilted towards the executive, do you think things would have actually played out differently in some of the instances of aggressions? And I guess underlying my question is just a sort of a curiosity that I have, or maybe something that I'm trying to understand better, is to what extent does law actually matter in Russia, is a question I find very interesting, because on the one hand it clearly matters a lot, and then on the other hand it seems to be fairly easy to maneuver around it as well for the executive, right? So and I had a related question there. So the rule, it's just a clarification question, the rule that the Council of Federation has to be involved in authorizing troops abroad, was that applied in Crimea or not?
Was that?
Applied in the Crimea case or not? Because it's an annexation, so probably it's not abroad, is my guess. But I was just curious.
And let's take one more. Ralph Michaels.
Yeah, thanks. I have two small questions for Bill and then a reaction to Christina's discussion. The two small questions are first on the role of comity. Especially under your definition of comity, it seems to be a general policy that inspires specific types of legal rules. And so the question is, beyond the actual restatement of these rules, what's the independent role of comity in that? If you define comity as that which states on their own decide to do within the scope of what international law allows, then comity doesn't, under Occam's razor, doesn't seem to play an independent role anymore. You just want to restate the foreign relations law. Relatedly to that, if you define it as deference to other states, but then oppose case-by-case analysis, as it's called. Case-by-case analysis seems to be a misnomer for something that is a bilateral approach, in the sense to say we make the deference decision on the basis of what we see on the other side. And that is case by case, because sometimes there's a claim to adjudicate and sometimes not, etc. An approach that opposes that and is unilateral, as is the presumption against extraterritoriality, doesn't seem to be deference anymore. It seems to look unilaterally to restrict the scope of US law without actually deferring, although somewhere deep in the background may be the policy interest to say, if we restrict ourselves far enough, we won't come into any conflict. But then the really interesting discussion that Christina began, and the moment she said maybe it was wrong, I realized this is the opening for how you're going to respond, and Bill and Ed responded in exactly that way, which is this is not our task, and we have to state how it's correct. First, I'm not sure that the third restatement was actually wrong in that regard. The one that I'm looking at 403, I think the question is still open. Hannah and I hope to look at that. The fact that they cite no more than British responses to extraterritoriality, maybe insufficient evidence, but that's different from saying this is wrong. Second, and maybe more importantly, the third restatement becomes for some time the restatement of international law for the world, right? So the world refers to the third restatement as the anchoring point for what international law actually is, and then with the discussion of whether individual provisions are or are not. And with many of them, the way of showing that it's not wrong is to say other countries endorsed it, right? Said ex post, this is actually fine. I would think that the tarring that we had in the United States was based on ideological and not methodological reasons. I think it's an opposition to the content of the restatement and not to the methodology. But if you switch the title of or go the other direction in the title of this panel from the Restatement of International Law, not to look what's the role of international law in the restatement, but what's the role of the restatement for international law. The big responsibility of the restatement drafters, whether you want it or not, is going to be that this is going to be taken to some extent as a restatement of at least a part of international law. And it will model an approach to international law for other countries, just as the third restatement did. And so you may well say that does not mean we should think normatively, we just try to describe the law as it is domestically. But it's one of the huge impacts that the restatement is likely to have, and one that I think deserves some of the concern and attention that Christina points to, just to put that out.
Thank you. Who would like to? Oh, we should answer some of these now and then go on to the last few questions. Who would like to go first?
So I think I'll leave Austin's remarks. But as to John's question, whether there are executive branch actions that may be inconsistent with U.S. law that might contribute to the formation of international law that is inconsistent with or in tension with U.S. domestic principles, I can say the reporters didn't deal with that question generally because we haven't and didn't undertake anything that was about customary international law and its effects domestically. My personal assumption would be that the president is bound by U.S. domestic laws or other actors, including the Constitution, but that we know that the U.S. can be bound by international law even if a U.S. actor contributing to the formation of international law has violated U.S. domestic law. And we know that from the laws of treaties and other international agreements, that it's simply not the case that simply an error in U.S. law will somehow deprive an international agreement of its effects on the United States. And that's actually been something that we do explore in the restatement and that the Senate and Congress appear to understand as well. I think that would also be true for customary international law, but that's not a point that we've examined. Ralph, just very briefly, because you're mainly about the substance, I think, of 403 and its successors. I think it's fair to view the restatement in some sense as a proposer of international law or as a forum for generating international law. And I think that's one of the ways that its success might fairly be evaluated. And we know, sure, that the restatement isn't a court. It's not trying to resolve questions and decrees in a way that is formally legally bound and in principle can view itself as an actor. But I guess I remain committed to a more boring proposition that is a dangerous mantle to assume. It may be a mantle that is thrust upon the project, but I don't think it's one that can productively be employed by it when its interlocutors include a lot of people within the Institute and otherwise, such as courts, who are evaluating it by its correspondence with a more near-term reality.
Okay, so to Ralph's points, I agree with Ed that I think that for the restatement for the American Law Institute to be pushing particular views of customary international law that it finds normatively attractive but aren't supported by state practice is, I think, dangerous. And I actually think it undercuts the role of international law, not just in the United States but abroad, because it makes it seem as though it's just something that international law experts dream up, or in this case, even more controversially, U.S. international law experts dream up. And I have a hard time seeing how that contributes generally to the international law project. I think we are on much safer grounds when we are more cautious in that respect. I do think that, I take your point about what work does comedy do if it's just a category that we use to lump all of these domestic doctrines together. But I do think that it's useful to have a name to put on that category of things. And not all jurisdictions, only common law jurisdictions really call it comedy. Civil law jurisdictions generally don't, and yet they have these doctrines too. I do think that there is a value in finding a commonality among these things. The analogy that occurs to me is mutual trust under the Brussels regulation, right? You may think that's useless too, but it's a linking idea. And it reflects something. In the case of mutual trust, it's, we've entered into this arrangement with these other jurisdictions, so we really need to take them seriously and not be second-guessing them all the time. In the case of comedy, it's that we live in a world where lots of stuff, including disputes, cross borders, and we need to accommodate that fact, and we need to accommodate other legal systems by showing some deference. And on the deference point, I don't agree that if you don't take into consideration the actual interests of a foreign government in the particular case, that it's not deference. I think one can have deference that is unilateral and deference that is multilateral. There are other comedy doctrines that act in a unilateral form too. Forum nonconveniens, for example, does not depend upon the existence of any actual foreign dispute to which it is deferring. Yeah, but that forum may or may not have an interest in hearing the case. The forum... It is case by case, but it doesn't depend, I think, on the interests of foreign governments in the way that, well, I don't know. I mean, maybe you and I need to talk about this further in terms of, my basic point is that I don't think that deference has to operate in this sort of way of saying, in the particular case before the court, what are the particular interests of the foreign legal system or the foreign government actor? I think it could operate that way. And some comedy doctrines do operate that way, but they don't all have to operate that way. So I guess I rejected the idea that the presumption against extraterritoriality doesn't involve, for example, it's unilateral, but I reject the proposition that it doesn't involve deference to foreign states. It may not reflect enough deference or the optimal level of deference, but that's a different question, I think.
Back there?
Yep. Mila, I would say that the Council is involved, and it's involved quite actively, at least if you look at the minutes of sessions when the authorization to deploy is debated. It's quite extensive. And incidentally, the rules of the Council provide for in-camera discussions on the matters of foreign deployments, although most of them have been done publicly. The only two instances when those debates were held in camera that I can think of was one, deployment to Kosovo, to the international UN/NATO, mostly NATO operation in Kosovo. And the reason the debate was held in camera, in my opinion, was because one of a group of members of the Council who were delegated by the predominantly Muslim members of the Russian Federation, they didn't want Muslim soldiers of Muslim faith to be parts of those units that would be sent to deployed to Kosovo operation. Although later they changed their position, but that's another story. The other instance when discussions were in camera was with respect of Syrian deployment, the initial deployment to Syria. And as I already said, the resolution was so terse that you cannot discern from the text of the resolution that it was about Syria. Only immediate subsequent, the events that immediately followed made it obvious that the authorization was for deployment to Syria. Now, I should also add that quite often the Council of Federation, in its authorization, and then later the President in his own decree would make references to international law. The counterterrorism authorization, that was the authorization to use armed forces and special units, special forces, following the attack on Russian diplomatic personnel in Baghdad, made a reference to Article 51 of the UN Charter, that's self-defense. I should also say that Russia seems to be developing a sort of its own authorization to use the military force doctrine. That is, we have at least two open-ended authorizations. One is more or less specific with respect to counterterrorism, that's following that Baghdad attack. The other is, which was adopted after the war with Georgia, and with the inability of the two branches of power to interact and give constitutional authority to deployment. Then there is another open-ended AUMF Russian-style resolution, which authorizes the president to deploy forces in certain circumstances. Crimea, the answer is yes. The Council of Federation was involved, although the resolution which was passed on the president's request, on the president's application, was about the deployment of armed forces to the Ukrainian territory. And it was repealed a few days afterwards. Does that answer your question?
Thank you. So we are coming towards the end of our time. We only have a few minutes left, but Kurt and George have had their placards up for a while, so I want to give them a chance to ask their questions.
Mine's more of a comment that might also apply to the next panel, so I can be very quick. Although it's prompted by your paper, Ed. And I'm surprised we haven't yet kind of said this yet, which there's something quite odd about doing a restatement, it seems to me, on foreign relations law that we haven't fully, obviously it didn't deter me from doing 6 years of work on it, but if you think about the common law topics where you have a bunch of state judges across jurisdictions deciding similar cases over a period of time, what you could, and by the way, doing kind of a common law policy-making, pluralist kind of decision-making that's allowed to be open-ended, you can see the kind of Burkean wisdom that you might say if you compared a bunch and you can pick out the ones that seem to be working well, and then there'd be a lot of guidance potentially by restating the ones that seem to be majoritarian or working. And that is nothing like the restatement form, not this one, but not the last one either. A normatively loaded area of public law, a fair amount of which is constitutional law, that has one decision maker at the top, the U.S. Supreme Court, when you have decisions, as opposed to a disaggregated, lots of similar jurisdictions that you're comparing. And getting to your paper, for example, not clear what the interpretive perspective is. So now I'm not sure we can say it, so I don't know if I have an answer to it, but is it the judge, the reasonable state common law judge? No, it is probably not. Is it the reasonable federal judge? I'm not sure if that's all that it is. So you raise a question about the executive branch. A lot of foreign relations law is not actually fairly judicialized, in which case, if there is law, what's the interpretive perspective? It might, to some extent, have to be some of the executive's views or actions. Why should it be the mythical judge who will never decide the treaty termination case? Just a question mark about where I'm supposed to be imagining myself to be the decision maker. And the more it's not a court, the more it opens up the things that you ask about. And then finally, another thing we don't, if we're getting into public law and constitutional law, what's the methodology? Big fights among the people who write in this area, even in this room, originalists and textualists versus pluralists and common law constitutionalists. We never say. What do? We basically are pluralist, I think, for the most part, and that's defensible on the ground that that's a lot of modern stuff is probably pretty pluralist, and, as opposed to the academic writings on the topic. But interestingly not a defended choice either. And I think it's all in part because it's very different from the common law project. You were next. Yeah.
So I just have a brief question for Ed. I listened to you carefully, and you said we should pay attention to what the sources of international law are, or the sources for the restatement. But you didn't say we should actually catalog them, which you just said be careful, and I guess I sympathize with your caution in this respect. It makes a lot of sense to raise this question, to get into it. I have no idea how you get out of it. And it seems to me that, when you analyze particular legal problems, the working view of almost all lawyers is some kind of legal positivism. Show me what the sources of law are, and I can give you an answer to this particular transaction, this particular dispute. But in a task like the restatement, you're taking a much broader view, and the admissible sources might not be an input, they might be an output of the whole process of restatement.
Reactions?
Well, I don't want to speak. Is this the last question? I don't want to say anything at the expense of other questions.
No, I think this is the last round of questions that we're going to take. So if you have final reflections, that is also welcome now.
I would just say, with respect to the last two comments, I agree with both of them. I think one of the questions we face is, as Kurt said, we don't just have the audience being federal courts, though we can scarcely afford to lose our credibility with them. So I think that they're a constraining force in that sense. We are seeking to have a degree of credibility and resonance with the executive branch and with the U.S. as a whole as well, but they, to a substantial extent, take their own guidance. And there is not the rich tradition of the restatement guiding more naive end users that you might find in some of the other areas of the restatements. It's more a case in which the end users are extremely sophisticated and have their own agendas and can harbor deep and never surrendered disagreements with what the restatement is inclined to say. And that is a tempering force. I think the best we can ultimately do is make sure that we are genuinely pluralistic in terms of the inputs that we receive and the kind of data that we survey, so that we can convince more constituencies that their views haven't been ignored and that this is truly, even if it is never rigidly defined, that this is truly a careful effort that takes into account the different constituencies.
I would actually just like to address that topic very briefly, which is I think it would be possible and useful to describe sources of foreign relations law maybe in the comments and reporters' notes to a section that defines foreign relations law, but I don't think it would be possible to come up with rules in the same way that one has rules and can explain them for customary international law, because the sources are too varied, and what ends up being the definitive source, or the ones that carry the most weight, varies very much depending on what kind of rules we're talking about and in what context.
There were no specific questions from me in the final round, but I would say that, again, going back to those interactions between various branches of government with respect of foreign deployments, we can witness diverging trends. And I gave a brief example of Israel or Russia. Even in Germany, when the Constitutional Court rules in 1994 judgment on the specific role of Bundestag and foreign deployments of Bundeswehr, including the peacekeeping operations, then there are caveats in later decisions about the practicability of involvement of Bundestag in certain contingencies where the exigencies of situation that do not allow for this role. So I don't think that there is a uniform and very clear picture here.
Thank you.
Just a two-finger on what Bill said.
Mm-hmm.
You know, at our very first meeting, with our advisors, we had a draft sources of foreign relations law provision. And the consensus in the room was, come back with this after you've done foreign relations law. So it is exactly a case where first you say what the law is, and then you say what the sources are.
Well, we are out of time, but we are going into a short coffee break that you can use to pursue the conversation, to continue the conversation. In the meantime, please join me in thanking our panelists.